like that takes us to the female side.
Yes, ma'am.
All right, I'll see you guys there. Thank you.
Herron Jones.
All right, good afternoon. It's calling case number 230-579-9101, people of the state of Michigan versus Herron Jones. Counsel.
People, P 72748.
Celebrate on behalf of Herron Jones, Your Honor. Waive the formal reading, stand mute at this time, Your Honor.
Thank you, counsel. Court notes formal reading has been waived. Enters a not guilty plea on your client's behalf. Noting for the record, this is a non-assaultive allegation with no priors, and I have a local address. Is there any objection to a personal bond?
There is not, Your Honor. There's no objection to a personal bond. This is information in the report.
Thank you. Defense counsel, I'm assuming no objection.
No objection.
Bond is set at $10,000 personal. Ms. Jones, you're not to purchase or possess any firearms or other dangerous weapons during the course of your bond. Okay, you don't have to pay to get out, but do not violate the bond condition. No weapons. Next court date, July 28th for probable cause conference in front of Judge Robbins. After that, preliminary examination is set for August 4th in front of Judge Jefferson. Thank you. Hi, what's your name, please?
Shakia Boykin.
All right, thank you. This is case number 230-579-9201, people of the state of Michigan versus Shakia Boykin. Counsel.
P 72748.
Celebrate on behalf of Ms. Boykin. Waive the formal reading, stand mute.
Thank you, counsel. Court notes formal reading has been waived. Enters a not guilty plea on defendant's behalf, and I'll hear arguments as to bond.
People are asking there to be a tether in this case. Court are very involved. Some stopping people and things. Your Honor, she's just asking for a tether because we do think that there is a danger of Ms. Boykin not appearing to court. Your Honor, Ms. Boykin has 3 other cases pending at this time. 2 of them with multiple cases. So she has an A and B that's actually from 2020, but she failed to appear for pretrial February 24th of 21, and she was arraigned on the bench warrant in August 22. Then she failed to appear for pretrial in November 22, and she just got arraigned on the bench warrant yesterday. And then she's got a current Michelle Frog with 3 case, which actually, interestingly enough, has the same location as this case. And then she has a pending case. The only remaining charge on the case is a less than $200. On that one, she was arraigned May of 2020, and then she failed to appear for an exam and still had felony charges on November 2nd, 2020. Then she was arraigned on the bench warrant August 10th, 22, and then she failed to appear for pretrial November 1st, and then was arraigned on the bench warrant yesterday. So we do think there's a list of not appearing to court, and that's why we're asking for the tether. Besides that, we don't have it.
Okay, thank you. Defense counsel.
Judge, my client's 36 years of age. Judge, she does have some priors, Judge. This is Ms. Boykin, right? Shakia Boykin, correct?
Yes.
Okay, Judge, and she lives with the grandmother in the city of Detroit, Judge. So she has strong ties, has 2 children. She is on disability currently, Your Honor. She's saying, Judge, that the complaint, a panhandler trying to attack the gas station, and she was just defending herself against someone that was attacking her, Judge. So, you know,
the investigator's report says they both had knives and that she's the one that got her face stomped. Quite frankly, that's what the report says.
Yeah, and she tells me, Judge, she was defending herself. So, Judge, it's going to come down to, obviously, you know, a case. If the complaint does show, they're going to, you know, have conflicting stories, and it'll come down to question of fact. At this point, Judge, I'm asking the court, no weapons, no contact with the complainant. I don't believe they know each other, so there's no reason for contact. And I would ask for a personal bond, Judge.
So she says she lives with her grandmother and she's not working?
She is not where she's on disability, Your Honor, right now.
All right.
Not living with grandma on disability. Two kids.
Right. So I'm gonna give her a personal bond, but I'm gonna require house arrest. I mean, she's got way too much going on. Doesn't seem to be able to keep herself out of trouble and from being hurt, quite frankly, being out there. So I'm gonna give her a tether with house arrest until she's back in front of another judge, because it seems like she just keeps racking things up. We've got all these cases pending, none of them really assaultive, besides this one that I know of, but I think I did hear one or two priors that were assaultive, but the pending cases seem to involve other things, but it's just way too much circulating around her in terms of community safety right now. So, and flight risk, having heard that there are capiases in other cases. So 10,000 personal, GPS tether, house arrest.
Thank you, Your Honor. What are the dates? I apologize.
July 28th for probable cause conference, August 4th for preliminary examination, both in front of Judge Giles. And Ms. Boykin, you are not to purchase or possess any dangerous weapons during the course of your bond, okay? All right.
Thank you.
All right, DDC, you'll need to unmute. I muted you because I was getting too much feedback. I won't be able to hear the next defendant that comes up. Hi, what's your name, please?
Brittany Bradley.
All right, Ms. Bradley. Good afternoon. This is case number 230-579-9901. People of the state of Michigan versus Brittany Bradley. Counsel.
For the people.
Deliberating on behalf of Ms. Bradley. Way the formal written stand.
Thank you, counsel. The court notes formal reading has been waived and enters a not guilty plea on your client's behalf. Looks like these are non-assaultive. The prior is also non-assaultive, it appears. Got a local address, positions as to bond.
That's correct, Judge. We already handled defendant 2. Defendant 1 in this matter, she was the driver. She was the one who was issued the citations in the vehicle, Judge. That's where the police officers found the fentanyl. And Your Honor, if this wasn't 1 or 2 folds, apparently it was 26 folds of fentanyl. Your Honor, and that's why she's being charged with the count 1, Judge, as well as the fact, Your Honor, is the entire time she ended up having her 3-year-old child in the car. So, Your Honor, we have fentanyl that's found in the car. We have cocaine that's found on her person. And then we have the defendant's child in the car at the time, Your Honor, and now this is a second offense notice. I'm sure Your Honor does remember, it was defendant 2 where the people didn't object to the personal bond, weren't asking for any tether. Your Honor, if the people are inclined to ask for a personal bond here, however, we would be asking for this court to entertain the tether. Your Honor, it's not about so much the flight, but as a result of the dangerousness that the fentanyl creates, Judge. I think we're all aware of the fact that this is a drug that kills, I believe right now we're talking about 70 to 80,000 people a year. And it doesn't appear as though this was for personal use, and that's why it's being charged the way it is. But people would ask this court to entertain the idea of this.
Judge, do we even have any idea that this Bradley knew fentanyl was in the car? I mean, just because she's a driver doesn't mean she actually knew it was in the car. I mean, I'm just being, realistic here, Judge. I know they charged her with it, but many times people that are driving get charged. The gentleman didn't get charged with it because he maybe wasn't driving, but that doesn't mean anything in terms of her knowing or having knowledge of it. Now, the cocaine, if it's on her person, yeah, I mean, that's pretty, and I'm not saying it was, Judge, I don't know, but I just would note that there's no knowledge of her knowing anything about any fentanyl, Judge. So I'm asking the court not to look at the fact that she did know. It's going to come out later, Judge, whatever's happening, but I would ask for personal bond.
And Your Honor, the people aren't here to litigate the case. The people are arguing the fact that that was her vehicle, as she was the one who went and getting the citation, as well as the fact that she has the previous conviction that she, Your Honor, I believe she was the older of the two. This is a 33-year-old versus the 20-year-old. It's the reasons why the people were arguing for just the personal versus this. Now, with all due respect to defense counsel, nobody's going to get inside of anybody's head at this particular moment in terms of arraignment. But just based on the allegations and based on the fact it was found in the vehicle that allegedly was Ms. Bradley's at the time, that's why the people would be asking this court to entertain that monitorization, because this, that,
Yeah.
as well as the fact, just the severity of what was found.
Thank you.
Judge, I'm sorry,
I mean,
that does make sense. She's 33, he's 20, so because she's 33, she should automatically know that there's friend on the car. I that's a great
well,
argument.
here's the thing for me.
That's not
Somebody
right.
thinks they've bought a lotto fold of heroin. They think they bought a lotto fold of heroin, a single lotto fold or two of heroin. It ends up having some fentanyl in it. Yeah, I don't presume that they know that. But somebody's got 26 knotted bags. That suggests to me that they know what they're carrying.
Judge, but if
And
it's
it's in her purse. It wasn't just placed in the car. It's in her purse. So it's on her. I mean, it's on her. So, you know, and it's extremely dangerous. I mean, 3-year-olds put things in their mouths. Most of us have now lost people to fentanyl. You know, it doesn't take much. So I am going to set a personal bond here in the amount of $50,000. Is she working, counsel?
Judge, she is not working at this particular time. Judge, she's on SSI. She gets disability. She has a bridge card, but she is not working, Your Honor.
All right. GPS with house arrest to reduce danger to the community of this drug moving around in the community. $50,000 personal bond. Next court date, August 1st for probable cause conference, August 8th for preliminary examination in front of Judge Sabri. Ms. Bradley, you are not to purchase or possess any illegal substances during the course of your bond. Thank you.
Thank you, Your Honor.
Hi, what's your name? Can you guys unmute at DDC again? Sorry. Hold on, ma'am. Just hold on 1 second. We're gonna asking you guys to unmute. Just ask the officer there to unmute.
Hello.
Thank you. What's your name?
Theresa Jones.
Okay, Ms. Jones. Good afternoon.
Hi.
This is case number 230-580-0101. People of the state of Michigan versus Theresa Jones. Counsel.
Samuel A. Wagon, Your Honor, for the people.
Your Honor, Philip Brenda on behalf of Theresa Jones, Your Honor. Waive the formal reading, stand mute, Your Honor.
Thank you, counsel. The court notes formal reading has been waived in interest of not guilty plea on Ms. Jones' behalf. I'll hear arguments as to bond.
Your Honor, this past Wednesday, the complainant and the defendant, the two defendants, one of this matter is just for Ms. Jones, the other defendant, Mr. Suggs, and Ms. Jones live next door to the complainant. The complainant and defendant Suggs got into an argument where the complainant alleges the defendant Suggs came over to his property and they started fighting. As they were fighting, the defendant Jones came over and stabbed the complainant in the back with a silver pair of scissors, Your Honor. Now, there are some witnesses to this incident who were interviewed, Your Honor, after, and they reported the complainant's facts that of what happened, Your Honor. In addition, the officers asked, well, it says to ask defendant White, who is the complainant and is a man. It says defendant White was asked where the scissors were located, and he entered her residence and produced a silver pair of scissors. But I think that's a mistake because he was never said to have scissors, it was the defendant Jones. So, Your Honor, I don't know what we're gonna do here because they live next door to each other. This was assaulted and he stabbed with scissors, as the complainant alleges. I think that the defendant should have a high personal bond and yes, evidence of arrest.
Thank you. All right, Mr. Reagan, I'll hear your bond argument. I'm particularly interested in whether or not she has someplace else to go.
Judge, Miss Jones can't go somewhere else, Judge. She's 62 years old, Your Honor. She does home care. Judge, maybe I'm reading this investigator's report wrong, but does it say that the complaint came over to his house and knocked on the defendant's door?
So,
Maybe,
hold on.
maybe I'm looking at it wrong, Judge, and I apologize.
No, because it is confusing.
My client says that,
Because number one, Suggs does not get charged at all.
right.
He's not charged. All right.
He's
So
not.
that's going to tell us something about what folks believe. He's not charged at all. I don't know. I mean, yeah, go ahead.
According to my client, Mr. Suggs and the complainant, they got into a fight, and my client simply was trying to remove the scissors out of his hands. She wasn't trying to stab anybody, trying to do anything, but there was a fight between the two gentlemen, and my client was trying to de-escalate everything. So I don't know. It looks like Mr. Suggs said that the complainant white, and his friends came onto his property, knocked on his door, and began assaulting him. And defendant Suggs, so I don't know where and how Ms. Jones got caught up in all of this, but she said she was just trying to de-escalate the situation between the people fighting. But yes, she gets charged.
Right. Okay.
I just want to reiterate at the bottom of this second paragraph. So officers are able to speak with witnesses who did not want to identify themselves. The witnesses were interviewed separately. However, their stories were consistent with the complainant's recollection of the incident.
Right. So, I mean, we have unidentified witnesses, right? Telling us these people are not coming to trial to testify. Probably they won't even talk to the police. They won't even tell the police who they are. And I don't know who they are. So, okay. So investigator's report is an investigator's report. There are two sides to every story. And in this one, the complainant and the defendant tell very different stories. They each say the other one came to their house to assault them. Neither of the men is before me today charged with anything. It's Ms. Jones. So what I've got to try to figure out is Ms. Jones is, she's not 18. So if this is something that she normally engages in, I'd expect to see a prior conviction, some record. I have nothing. I have no priors. Okay. So that causes me to believe that there may be some credibility to the story that she's telling. I don't know. We've got some apparent minor injuries consistent with the stabbing, but no medical treatment. So there's a lot going on here in terms of, is this mutual combat? Is this defense of another? I don't know. But in terms of whether Ms. Jones is a danger to the community, I don't think so. I think this is an anomaly. If it in fact happened, it is an anomaly. However, counsel, you said she does have somewhere else where she can stay?
Yes, she will. Yeah, absolutely. Absolutely. She has two hit or she will stay somewhere else. Yeah.
Okay,
Absolutely.
so Ms. Jones, you're not going to be allowed to go back to the block where this is alleged to have happened. Okay, you can't go back on that block right now. But I will set a personal bond in the amount of $50,000, given the lack of any priors. And I don't have anything to indicate flight risk to me. I'm going to do a personal bond here because I don't see an overall danger to the community. I do think these folks need to stay away from each other. So Ms. Jones is not going to be allowed to return to this area, the block where this is alleged to have happened. You're going to need to find somewhere else to stay until you ask a judge and a judge says otherwise. Do you understand? Just nod your head yes if you understand me. All right, so yes. Next court date, Also, no contact with the complainant or attempted contact. That's Richard White. No verbal contact, no written contact, no contact with third parties or social media. Any attempted contact will be considered a violation of the conditions of the bond. You are not to purchase or possess any firearms or other dangerous weapons during the course of the bond. Next court date, probable cause conference, July 31st. Preliminary examination, August 7th, both in front of Judge Jefferson. Thank you.
Thank you very much.
Thank
Thank
you.
you, Your Honor, very much.
Are you Ms. Herron? Brenda Herron? Okay. Ms. Herron, you've got a traffic misdemeanor where you missed a court date. When you missed your court date, the judge assigned to the case issued a warrant and set a bond. I'm going to set the warrant aside today, give you a personal bond on the ticket. You do have the right to remain silent. You're being recorded. Anything you say could be used against you in the future. You also have the right to have an attorney represent you on the ticket. If you can't afford one, one will be provided for you on or before your next court date. This is a misdemeanor for which the maximum possible penalty is up to 93 days in jail and or a $500 fine. The ticket is U5171631 alleging July 4th of 2019 at Saratoga and Gratiot that you were drinking in public. All right, next court date on that one is a pretrial August 18th in front of Judge Millhouse. Personal bond. Now calling case number 230-579-9401. People of the State of Michigan versus Brenda Herron. Counsel.
Thank you, Your Majesty. Good afternoon, Steve Benson for the people.
All right, thank you.
Deliberating on behalf of Ms. Herron, Your Honor.
Thank you.
Well, I'm sorry.
Waiving formal reading?
Yes, Your Honor. I'm sorry. I'm not used to this. Yes, Your Honor.
No problem. Court notes formal reading has been waived and will enter a not guilty plea on Ms. Herron's behalf. I'll hear arguments as to bond.
Your Honor, I understand it as it's the defendant's birthday today, and in lieu of that, the people aren't going to be asking for a cash bond. We'll be asking for a personal bond. However, we are going to be asking for a tether in this matter for the reasons as stated, Judge. And just a matter of housekeeping, and Your Honor, the people at this time don't have a reason for this, but to have offender court notice, as I'm sure defense counsel knows based on his investigation of this matter, is off. There are multiple other convictions that we have in armed robbery in 03 where she was discharged in 18, where then she ended up picking up this attempted armed robbery in 19 again, as well as a controlled substance case. She ended up getting discharged from the unarmed robbery, and it was an attempt, Judge, in full candor. But she got off a little over a year ago, last year, and she does have an additional controlled substance. Now, Your Honor, the irony in this is there's about 5 or 6 convictions. 4 of the 6 cases that she had were cash bonds. The 2 cases that she didn't have cash bonds, she had capiases that turned into cash bonds. So, Your Honor, ultimately, in all of the cases that this defendant has been involved in, there have been cash bonds. So there potentially could be an argument, hey, we had 6 convictions, we only had 2 capiases, but that was because in the other 4 cases, they were cash, and those 2 personals turned in converted because of capiases. Now, in this particular matter, Judge, it is being charged as the controlled substance. It is a have forth notice, and potentially as a result of how it's being charged, the enhancement, potentially this defendant is looking at life. She does have previous controlled substance convictions. She does have on its face at least assaultive type convictions as well. It wasn't assaultive here, Judge. This is a situation where they ended up finding a reasonably substantial amount of cocaine divided up into 18 small Ziplocs, which would infer that it is a personal use, that it would be used for some type of delivery. That's why, Your Honor, based on the non-assaultive nature, people aren't going to be asking for the cash bond as well as the birthday here. But we would be asking for potentially this court to entertain the GPS tether and home arrest based on the history to support the idea of Your Honor, of all the previous cases and how they ultimately alter.
Thank you. Defense counsel.
Judge, not only is it Miss Huron's birthday today, it is her 50th birthday. She turns 50 today. I do understand counsel's concern, Judge. She was just released from prison in March of 2021. She was released from parole, I should say. She was released from prison a while ago, but she got off parole and she's back, with new allegations. So I do understand the concern. It is not assaultive, Judge. She does have children. She's on SSD. She gets disability, suffering from a few different conditions. But I am asking for a personal bond, Judge, and I will leave it to the court's discretion as to obviously the yes tether, Judge.
All right, thank you. First of all, happy birthday, Ms. Herron. All right, this will be a personal bond. However, given the arguments regarding capias, I'm going to put a tether on her. It seems like normally cash bonds are what's required for her to show, but we've not tried a tether yet. It doesn't sound like, so we'll do that to try to avoid the capias issue. Bond is going to be set at $20,000 personal.
And Judge, if I
GPS tether before she leaves the jail with no restrictions. I'm not trying to restrict her movements. I'm just trying to make sure we know where she is so we get her back for court, given the number of things that we've got going on right now. Yes, counsel.
Judge, if I can ask respectfully, I do note that she does have significant history, as brother counsel said, that potential life. I don't think that's going to happen, but a potential life situation, Judge, with the number of charges. But since 2021, has she had any capias on anything new? She was released off parole. And the only reason I ask that, Judge, is sometimes, prison can change, make you sit down, think about certain things. This is her 50th birthday today, and these are allegations. Obviously, she's not proven guilty. She hasn't been proven guilty. But I mean, she's got to wait at least a week for a tether. I'm not going to sugarcoat this Friday. She probably won't be looking at the tether until Thursday, Friday next week. So I only ask that because I do know she does have a capias history, but is it after she was released or was it before, she was, went to prison? And because I don't have that information that brother counsel has, Your Honor.
Counsel, do you know?
Your Honor, I do know. It was, one of the two cases was in 05. The other case was in 19. That happened at the close in time to the action that ultimately got this defendant in prison. The point was this, and I, quite honestly, and with all due respect to defense counsel, I thought the people were being more than fair asking for the personal bond and not for the cash bond. It was the fact that in the two cases out of the 6 cases that the defendant's been involved in, that because they were personal bonds, she capias that converted into the cash bonds. The history, quite honestly, shows that if there is, whether or not defense counsel, and I argue, or I appreciate the fact that he's making the argument that she's been changed. However, Your Honor, the people would stick to the idea that she was given previous chances and she continued to capias under the conditions. So with that being said, we're still going to, of course, let Your Honor, but we would argue adamantly that.
All right. Thank you. Bond will remain as is, $20,000 personal, GPS tether without restrictions. Probable cause conference set for July 31st, preliminary examination set for August 7th. Both of those in front of Judge Jefferson. Ms. Herron, you are not to purchase or possess any illegal substances during the course of your bond, ma'am. All right. Thank you.
Thanks,
all right, DDC, see you later. You guys have a good one.
Very much, Majesty. Appreciate you.
Yeah. Thank you.
Great.
You guys are the court jesters today, then, I guess. All right. Bye.
Thank you.